law in modern states. And the goal of our panel was to highlight the Western perspective, or maybe more specifically, the American perspective. Typically, when we discuss questions relating to the accommodation of religious law, the focus is on family law, and the question that is commonly raised and discussed is to what extent you can enforce religious principles in the context of personal status matters such as marriage or divorce, and how we should resolve tensions between religious law and secular liberal legal values and principles. And indeed, both Professor Broyd and Professor Bix focused their presentations on this traditional dilemma of religious accommodation. Professor Bix's work, as we all heard, analyzes the treatment of religious agreements by American courts. Professor Broyd examines attempts by secular society and law to regulate marriages and divorce of three sub-faith groups: traditional Jews, observant Muslims, and fundamentalist Mormons. Professor Bix concludes that on the constitutional issue, courts largely agree that Islamic or Jewish marriage contracts can be enforced only where this can be done based on secular, or more specifically, religiously neutral principles of law. His analysis highlights ways in which concepts of individual rights matter when religious agreements are interpreted and enforced. Similarly, Professor Broyd identifies a formal intention to ensure fairness when regulating marriage and divorce of different religious groups, although he also points to a potential gap between formal intention and practical results. In sum, what Professor Bix and Broyd describe to us is a legal world in which the separation of church and state and principles of gender equality matter and guide the work of legislators and judges. Professor Rao and Professor Carbone and Khan diverted the focus to recent developments in abortion law. In search of new developments in the accommodation of religion, they shift the focus from the private sphere of personal status matters to the public sphere of abortion regulation, and use the recent court decision in Dobbs as a telling example of where we are heading and what are the new challenges as opposed to the traditional challenges in the context of law and religion. Professor Rao argues that recent developments in abortion law suggest that the separation of church and state has been erased. The implication is clear. If secular values used to provide a traditional framework for the accommodation of religion, this is no longer the case. Following the court decision in Dobbs, states can now impose the contested anti-abortion views of a particular sect of Christianity upon dissenters. Hence, based on this analysis, it appears that the focus of discussion should no longer be the accommodation of religion, but rather the domination of religion in the public sphere and the manner in which abortion law is now governed by strict religious principles without the traditional limits of secular liberal values. Professor Carbone and Professor Khan move one step further. They hope to mitigate the harsh consequences of Dobbs and provide a theoretical framework for shaping the response to Dobbs. They use what they term punishment lens to analyze the jurisprudence of the court and discuss the circumstances in which the court has simultaneously concluded that the state could regulate but could not punish. They trace this approach of regulation without punishment in Justice Kavanaugh concurring opinion in Dobbs, and argue that this framework can serve as a means to de-escalate the coming legal wars over abortion access. In their opinion, what is required in the post-Roe era is to urge the court to take seriously its own statement that all it has to do is just to return the issue to the states. Taking this statement seriously requires protecting the rights of states that wish to secure access to abortion and protecting, as Justice Kavanaugh suggested in his concurrence, the constitutional right to travel. Hence, what Professor Carbon and Kahn hope to see in the post-Roe era is a Supreme Court that on the one hand allows states to decide their own approaches to abortion, while on the other hand protects the pathways out of states that ban abortion and ensures that doctors can protect the lives and health of their patients. But this hope might reflect the traditional understanding of religious accommodation that respects the separation of church and state and subjects religious principles to the constraints of secular legal values and rights. I wonder if this is still a valid understanding, and whether Dobbs should not be read as indicating a significant shift in the relations between secular law and religion. It might be that following Dobbs, we should no longer restrict our discussion to legal analysis that focuses on the accommodation of religion by secular law, but also uncover the new ways in which religious law now replaces secular law. So in conclusion, I think that abortion law is a good place to start discussing new developments in the accommodation of religious law and in the relationship between the secular state and religion. The full implications of these developments and what they imply in terms of women's status in society and gender equality remain to be seen. But as we think of these questions, we should acknowledge that the Dobbs Court did not only send the abortion issue back to the states, it also exempted the states from any future constraints on abortion restrictions, allowing the states to adopt the harshest bans possible. In his majority opinion, Justice Alito made clear that it will be almost impossible to challenge future abortion bans because these bans will be subject to the lowest level of scrutiny that is applied to challenge laws. The implication is clear. A state decision to impose a complete ban on abortion because of its desire to embrace a certain religious conviction that life starts at conception would most likely be affirmed as rational and as promoting legitimate state interest. So what are the new developments in the accommodation of religion in the United States? Our 5 speakers provided nuanced answers to this question. While issues of religious accommodation are still raised and discussed in the traditional domains of family law, recent developments in abortion law appear to challenge our traditional understanding of what religious accommodation entails and whether secular liberal values still guide the accommodation of religion in the public sphere. So thank you all speakers again for your marvelous presentations, and I now open it up for discussion. So I wonder if members of the panels, if you want to respond to each other, or if just people around me have questions, comments, whatever. Yes, go ahead.
I have a question for Michael.
and you can use the mic.
You talk about successful. I know in your abstract you say you're going to tell us what successful is. I don't know if you got there. I didn't really catch it because I don't know what successful intervention means. Are we protecting? Are we trying to not protect religion? Like I don't know what that means. And so I wondered if you could clarify what you meant a little bit. And then question for you, Radhika, is when I teach abortion law, I'm always very careful to tell my students that you don't have to believe that life begins at a certain stage to be pro or against abortion, because you can have an interest in the potential life even if you don't believe life begins. And I also use Judith Jarvis Thompson's example of how it can be afterlife, and because I think that there is a tendency to simplify it too much and say, well, if you think abortion, if you think life starts here, then you're again. And so I was a little bit surprised that was the way you set it up, because it could, I don't know, because I don't think we could ever agree on when life begins. I don't even think you can clearly say what Jewish law, I mean, Jews might not think. I think that it's really, really complicated. And so I try to teach my students about how it's really about privacy and women's bodies, or, that's on the one hand, and on the other hand, this desire to protect essential life. And that's also what the Supreme Court says in Dot, that it's about potential life. So I wonder how you respond to that.
Can I start?
Sure. Yes. So great, wonderful question, and I oversimplified to try to get it onto a slide. But actually, many of the religions take this more complicated view, including Judaism.
Right.
So I think really for Judaism, it's about when life begins, and it's also about burdening women or putting women over fetuses. Women's bodies, women's health, women's lives matter more. And that's true also for Buddhism and Hinduism. So one of the things that was really interesting to me in the religious research was finding that even, it's more nuanced than I put up there. So, Hinduism says that abortion is an adharmic, against dharma act. But we think it should be left up to individuals, and they should deal with the spiritual karmic consequences with their God, not that the government should be intruding upon this question. And same with Buddhism. And Buddhists were one of the largest groups in favor of permitting abortion in the United States, as were Jews. So I do think it's more complicated. I also teach Judith Jarvis Thompson, and in the paper I should go into that, but I was kind of oversimplifying here. So thanks for bringing that up. Michael?
I think that how you define success depends what you perceive to be the best outcome. How you define success depends on what you perceive to be the best outcome. And as I hinted at the end, there's a vast dispute as to whether we think empowering religious communities through contract so that they can self-regulate and take responsibility is a success or a failure. I think that there's no single coherent answer to that question. I can share with you my opinion, but this is just an opinion. It's clear that the Federal Arbitration Act is empowering religions to successfully regulate their own community who are foolish enough to sign arbitration agreements. As to whether this is a good idea or a bad idea, or will ultimately be successful in the grand sense of success, is very hard to know. 15 years ago, when I sat on the Bethlehem in America, I sat in a public event and I said, who would sign an arbitration agreement agreeing to give the Bethlehem in America authority to resolve all disputes in their life whenever they might arise? And then I looked up and smiled and said, I sit on this board, and I wouldn't sign that agreement. Would you? But many do. Many do.
I have a couple of questions. So I'll follow up with Radhika. Do you and you clerked for Justice Marshall? So I wonder, what do you think about the opinions that were heard ever since the Dobbs decision was actually leaked that Roe was decided in or reasoned in a wrong way, and it should not have, of course, focused on privacy, but on bodily autonomy and equality, in fact, gender equality. And do you, the way, actually it's a question for the three of you, do you really think that it would have made a difference? Maybe not now with the current construction of the court, but over the decades that have led to this, to where we are now. So yeah, and to Michael, and actually to Brian also, the prenup decision. I was this was new to me. Mentioning this, what's the name of the decision? The Wixler decision. Sounds like a shadow docket. I mean, I wasn't even aware that there's this system in other courts, unpublished. But was it reasoned? Did they, for example, did they mention? I think it was Avitzer case that this seems to completely ignore or potentially overrule.
Great question. On the equal protection issue, Justice Blackmun was always very defensive about this because he would get criticized a lot about Roe and why didn't the court decide it on equal protection grounds? Number one, at the time that Roe was argued, gender equality was not even considered to be a suspect, quasi-suspect class constitutionally. And in fact, the year after Roe was decided, the court decided this case called Geduldig, where it essentially held, even if gender equality had been considered to be quasi-suspect at the time, in Geduldig, the court says pregnancy discrimination is not sex discrimination because the law discriminates between pregnant women and non-pregnant persons, and that's not the same as a line between men and women. So the court could not have decided based upon gender equality because it didn't have the gender equality jurisprudence at the time that it decided Roe, nor were those arguments presented to it. But Alito, in his majority opinion in Dobbs, although equal protection was not actually presented to the court, that argument in Dobbs, he goes out of his way, the majority goes out of their way to raise the issue only to dismiss it in a brusque paragraph that horrifyingly cites as authority Geduldig, that most infamous decision. So, just another horrible element of Dobbs is this kind of reaching out to decide a question that wasn't even presented, and to do so in such a dismissive and ridiculous fashion, and also to harken back to history and tradition, in 1868, when women weren't even granted the right to vote, to look to the contours of what rights should be protected. Do I think that it would have made a difference? The court did, ultimately in Casey, recognize that gender equality was also an essential part of the abortion decision. And Justice Blackmun, in his concurring opinion in Casey, explicitly talks about gender equality and the burdens. And even Roe itself talks about and relies upon the burdens that pregnant people, pregnant women face particularly. And it didn't seem to have made a difference, that Casey recognized it that 30 years ago. And I don't think it would make a difference with this court, even though many people have criticized Roe on that grounds.
Naomi, did you want to add? Are you there?
Naomi, can you hear us? Naomi? Oleg?
There's something on the chat, maybe? Did she write something on the chat?
That's my job, put it
She's there.
straight.
She's raising her hand. She's been muted.
Oh dear.
Or she has to open hers.
No,
It says red microphone there.
yeah, she has to unmute herself.
Yeah, that's what I think. You're muted, Naomi.
Oh, okay.
No, she's gone.
I don't
don't think she's there.
Thank you. I could not